So I'm David Maisuraja, Associate Professor at Law School at Ilyas State University. We invited Professor Kристиνα Blasi from Autonomous University of Barcelona. For the last several years, we established close connection with them, and I think in the nearest weeks it will be also highlighted in the memoranda with the Autonomous University of Barcelona and Ilyas State University, and the memorandum will indicate the close cooperation among professors and potential exchange for students as well. So today, Professor Kásagranma will address data protection issues and new directive on data protection. Data protection is an important thing not only in Georgia but worldwide and internationally. And I would like to say, first of all, thanks to her for coming here, and I think it was for about three hours.
Yeah.
And I also would like to say thank you very much to our students and staff who, due to many common reasons, still have the time to come and continue our primary role at our university. Education. Thank you very much.
Thank you, David. And thank you everybody to be here. David told me that we are in current city political or like there's a lot of demonstration outside, but you still are here with me, so I really appreciate that. And I hope that you will be interested in the topic that I'm going to introduce. As David was just mentioning, we established really good connection between this university and my home university in Barcelona. It was a couple of years ago, and we're trying to improve that, like to promote this relation among both universities. So for me, it's my first time in Georgia. I'm really enjoying it so far, and I'm also excited to have a new audience, which is completely different from my normal audience. Like I'm normally teaching Spanish, also some English, but my audience is basically Spanish. For me, it's a challenge right now because I'm going to assume that you know nothing about what I'm going to explain. I'm going to start very basic. And honestly, I encourage you to ask me whatever you want, because my goal here is to just give you a few basic concepts about the law in Europe, and particularly privacy and data protection law. But I'm not I'm going to just expect that I just want you to have a first introduction, and I obviously am going to emphasize whatever is also relevant for Georgian lawyers because of the relationship between the EU and Georgia. So I'm the first part of the lecture is going to be basically on GDPR. GDPR is abbreviation for General Data Protection Regulation, which is the regulation that we have in Europe, covering the 28 member states. And this is going to take, I'm going to try to use like an hour and a half to cover that. Then if you agree, we can have a little break. And then the second part of the lecture is going to be particularly on data transfers between Europe and third countries. That I think is going to be relevant for you because this is what Georgia should implement if they want to transfer data to the European Union and vice versa. So I think that here this is also going to be relevant. Without more delay, let's get started with the first part of the lecture. And this is, as you can see in the title, data protection in the EU, GDPR. Okay. So as I said, I'm going to start by explaining a few key concepts that I think is useful for the rest of the presentation, which is basically the difference between privacy and data protection. There's a lot of people who tend to mix these two concepts, and I don't really, I'm not surprised about that because sometimes they are really very much interlinked. but they are not the same thing. So I'm going to spot right now a few differences between what is privacy on the one hand and what is data protection on the other, okay? I'm also going to go into how all started in the European Union. Why are we so obsessed about data protection? Basically because the EU is pretty much a model for the rest of the world in terms of promoting and trying to improve and increase the standards of data protection. Why is that? I'm going to go into the very origins of that and then trying to get into the current situation in 2019. And finally, I'm going to give you a few novel concepts and clauses and provisions of this new GDPR. It's not that new anymore. It was adopted in 2016. It was finally implemented by all member states by 2018, so last year. And now it's already 1 year old since everyone has already implemented it. So, yeah. Now, what is the difference between privacy and data protection? So, if I should give you a very easy way to understand, you can think about something that for you is private, right? Maybe some of you will think of the fact that they don't want to disclose the things that they do at home, right? Whatever happens at home stays at home. You don't want to disclose that to your friends. Other people will want to disclose that to their friends. That's why, for example, nowadays there is this like increasing tendency to use social networks and to publish everything that we're doing when we are eating food, right? And we post a photo about what we are eating, or when we are hanging out with our friends and we are also posting photos and let people know about what we're doing. This is really relative and subjective. Some people will be more private than others, right? So when we're talking about privacy, you have to think that this is really subjective concept. Whatever is private for one person is not going to be private for another person, right? But regardless, everybody has some aspects in their life that they don't want to disclose, that they want to keep by themselves, right? And this has to be protected. This is what is supposed to be protected by this concept. Everybody has to have an aspect and different things of themselves that they are going to keep in themselves and not to disclose to the rest. This is different than data protection, because even though we're saying that privacy could be different from one person to the other, the data that belong to us, they are equal for everyone. For example, you have a name, right? You have surname, maybe two. I have two surnames, Blassi, Kazakh. Other people have one. You all have ID, an ID number, which is different than the other person next to you's ID. You also have an address where you live, right? And a telephone number. These are things that are unique. This is data that is unique, okay? Why is this unique? Because if you put this data on a paper and you show it to another person, for example, this person will be able to identify you. By giving this very particular data, you can be identified, okay? That doesn't mean that it happens all the time automatically. Maybe if your name is John Smith, there will be like 1,000 John Smiths, so you will need more details or further investigation to really understand who is this person. But eventually, you might be identified. This is the data that we're talking about. Personal data is the data that make you identifiable or identify yourself, okay? And this is something that needs to be protected. Why? Because it belongs to you. It makes you unique, okay? This is something pretty new, because in the past nobody didn't really care about protecting this personal data. Why? Because it was not that easy to really come across someone's data. But with the era of internet and technologies, that makes it super easy, instantly. Like nowadays, so much personal data is out there. and then available for everyone else in the world. And that's when the European Union realized we need to improve our regulation and our laws in order to protect that, right? Until then, we only had privacy as like the fundamental right that needed to be protected. And that was mostly considered for cases, for example, in which someone would open someone else's letter, or like the other very traditional correspondence that we used to have. But nowadays, privacy is also something that has to be increasingly protected because of the new technologies which make it so easily available for everyone. So, after this introduction, you can realize already that these two concepts are pretty much interlinked, but they are not exactly the same. So, in terms of the scope, I would say privacy might be a little bit broader than data protection because it covers not only data, but it can cover anything that you want to keep private. Okay, it doesn't have to be your personal data. It doesn't have to be your name, your surname, or whatever. It can be like the fact that you like eating chocolate and you don't want to disclose that you like eating chocolate, and it's fine, right? Or it might be that you just bought the other day a pair of socks that you really love, and this is part of your privacy, right? You don't want to disclose this information. So privacy could involve anything, right? It also includes legal persons, and this is actually very interesting because, companies could also benefit from this right, the right to privacy. Imagine that McDonald's doesn't want to disclose the practices that they're using to prepare the burgers, right? And the conditions that they give to their workers or whatever information they want, they also can be protected by privacy. But legal persons are not eligible to be protected by the other sort of concept, data protection, because this is only, and this goes to the to the green, the green boxes. Data protection is only applicable to natural persons, you, me, but not companies. The workers in the company, they might be subject to data protection. And that's why if you're thinking about a company with only one worker, then obviously this person will be eligible. But not a company as such, okay? This case, I'm not going to go into it, but this is an interesting case. I don't know if you know how the European Union functions, but in the European Union we have a lot of institutions. I'm not going to go into details with that. And we have also European courts. The main sort of like European courts are European Court of European Court of Justice, and this European Court of Justice seeks to interpret EU legislation when it's needed. And in this particular case, the Breyer case, there was a question saying, are IP addresses, dynamic IP addresses, I don't know if you are familiar with the subject, but there is a static IP addresses and dynamic IP addresses. Static IP address is only when you're using one same computer with the same IP, and whatever you're searching, it's always like the stored IP is going to be always the same. Dynamic IPs are the ones that are changing all the time whenever you are connecting to a website. So in that case, the actual question was like, is a dynamic IP address could be considered part of personal data? And the answer was yes. The answer was yes. And that also shows how, when we're talking about personal data, we can go to the very basic personal data, like as I mentioned, right? Name, ID, telephone numbers, and license plate, and so on. But you can also go to very specific and maybe more novel types of data, like IP addresses, which eventually are going to identify you, and that means that even if it's indirectly, it's considered part of your personal data. And this was one of the kind of landmark cases showing that. Another concept, when we're talking about data protection, it's a very complex subject, and there's very, very specific terms that we need to understand. I put some of them here. So we use a lot of processing personal data. What is processing? Well, processing is pretty much everything that you can do with data. So processing would include, for example, collecting data. Processing would include also storing data. It would include sharing, transferring, I don't know, retaining, anything that you do with your data is considered as part of the concept processing, okay? So that means that when we're talking about protecting data, protecting personal data, we're protecting it from any sort of processing that some website or some user or some other person could do with our data, okay? When we're talking about data subject, who is the data subject? Well, data subject could be you, could be me. Any person who has personal data, so any natural person, is a data subject, could potentially be a data subject, okay? What is a data controller, data processor? This is something that you will also read a lot if you are interested in this topic. And it's not always easy to differentiate what is a data controller and what is a data processor. So I'm going to give you an example for you. So imagine in the future, when you finish your degree, you're going to go and, have your own company about, I don't know, real estate agency, okay? You want to do that. You build your company, right, and you start your business, and then you realize that obviously you cannot do everything by yourself. You need some help. You need to subcontract some of your services, maybe, right? And you decide that you want to subcontract, for example, let's say all the thing related to the budget, the benefits, the profits that you got every year, and do a little bit of, all the numbers in terms of, checking if your company is going well or not. And you hire an accountant, and this accountant will do all these numbers, right? But in order to do all these numbers, this person will have to know, how many properties have you bought, have you sold last year, so how much profit you got from every property, everything, right? So they will need, this subcontractor will need information about customers, about, the people who was buying and selling. All this includes personal data, right? Well, so now my question is, who do you think in this sort of hypothetical business in which you are the owner of that business, who is the data controller and who is the data processor? Would you say that you, as the owner of the business, you are the data controller or you are the data processor? You would say processor? Someone would say controller, maybe? Okay, I see some duality here. Well, you as the owner of the business, you are the controller, but just because the client, the customer, gave the data to you, right? When you were managing the purchase of the property, whatever, there was this exchange of data between the client and you. It was later on that you decided that this data would have to go to this second subcontracting company for the accountancy. But the client will never know that you have subcontracted that. You have decided unilaterally that you want to delegate some services to a third person. This third person is going to be the data processor, okay? You are still going to keep remaining being the data controller. That means that if something happens to this data, something happens later on, and this accountant hacker and the data is compromised, you as data controller are gonna be the responsible for that. Unless, and this is something that we have incorporated recently, there has to be very well determined contract between the data controller and data processing, saying the conditions and obligations of each of them. So it's an obligation that whenever you decide to send this data, that it's not yours, it's from someone else, your customer, to a third person, you need to establish that very, very, very accurately in a contract, and all the conditions need to be established. And what is this data used for? When is this data going to be deleted? When is this data going to be, I don't know, like accessed? And who is going to access this data? For what reasons? Everything has to be very much detailed. Because otherwise, the data controller is going to have a big problem if something happens later on. Okay? Before 2016, I have to say there was almost no obligations by data processor to comply with any of these obligations, so data controllers had a big responsibility. Now with the new GDPR, we have kind of balanced that, and data processors will still be responsible if something happens later on this data. We were here. Another last concept I want to emphasize is sensitive data. Can anyone tell me, I don't know, I mean, maybe you don't know, but let's guess. What is for you, what would be for you a sensitive piece of data? Oh, that's good. What's your name? Nata. Yeah, Nata said disease. So this is basically health data. Yes, correct, Nata. Anyone would think about any type of data that is considered sensitive besides health? Private pictures, no. I mean, it depends, like, we have to think that every picture is different, obviously, but in general, when we're talking about picture as such, it's just personal data. Unless... Family.
Yeah.
Family, you mean father, mother, sister, or...
Yes, with some publishers.
I mean, what I have to say is that if, for example, this picture shows something related to your sexual orientation, then it would be sensitive, okay? For example, your partner is the same gender as you, for example, that could be, or different, whatever, but if it's about the sexual orientation or sex data, that would be also considered sensitive. Okay, let's go and check what else. So basically, we have two pieces of legislation where we can see pretty much the same sort of categories of sensitive data, but they are not exactly the same. So we have, I'm not going to go into detail in a minute, but we have the Council of Europe Convention 2008, and then we have the GDPR, okay? And they both explain what is for them categories of sensitive data. They include race, ethnic origin, anything that has to do with political opinions. Religion is something sensitive. You shouldn't be disclosing your religion, right? Other beliefs that you have, it's also considered part of the sensitive data. Health and sexual life as well, as we have mentioned by Anita. Then the GDPR goes a little farther and also considers sensitive data anything that has to do with trade unions that you are joining, or, and this is really novel, genetic and biometric data. This should not be a problem, but recently, come on, and a lot of you guys, probably you access your phone already with your fingerprints, right? And all other sorts of things. Well, you're giving to these companies for free the most precious, sensitive data that a person could have. Fingerprint is unique. There is nobody that could replace that from you. For example, what else? DNA. DNA is also unique. It's start genetic and biometric data. This is sensitive data as well. And why is it relevant that we classify that as sensitive data? Well, as I will explain in a little while, you need a more specific, explicit consent to provide this sort of data. It's not as easy as, oh yeah, you can use it. No, you have to sign it, you have to expressly give this consent because it's considered to be, it's a very relevant data, so it should be treated differently. And sexual orientation. By the way, for the Convention the Convention 108, also criminal convictions could be considered part of sensitive data. So, for example, if you have criminal records and you want to keep them for yourself, that should be also part of the. Obviously, it's very private, especially if you have, been convicted. You have complied some sentence, and you want to just keep going with your life without that being affecting it. That is also part of it. Now, I was talking about different regulations on data protection, and particularly, I don't know if you have realized, but I was mentioning Convention 108 and then the GDPR. But let's get me starting from the beginning. And the beginning is that data protection was really important for the European Union since the 1950s, since the European Union was created. As you know, the European Union was created right after the Second World War. As you can imagine, after this big world war, the whole European Union was pretty much destroyed and really broken economically, and a way to create peace and to reactivate the economy was to start to create agreements among the member states. And first of all, the origins of the EU were pretty much economic. So it was Germany and France, and then later on also Belgium and Italy and some other funders decided to create some economic union, and then this has been evolving. But besides this, another international organization was created after the Second World War, which is the Council of Europe. The Council of Europe, even though it's considered to include all Europe, it's much bigger than that. It's called Council of Europe because it started in Europe, but it includes nowadays 51 countries, participant countries. I don't know if Georgia is part of it. Of the Council of Europe, do you know? I have to check. Anyway, the Council of Europe created a lot of interesting regulations to create peace. So the idea behind this international organization was, let's make each other friends again and not create other further wars, and let's do that by creating some principles that we should not break anymore, right? And to promote peace and so on. In particular, there is two instruments that I'm going to refer to because they also emphasize a lot the privacy and data protection concepts. The first one, which you probably will have some knowledge of, is the European Convention of Human Rights. I don't know if you've heard of it. European Convention of Human Rights, as the name indicates, establishes a bunch of human rights that every participant country has to comply with. There is the right to life, there is the right to the prohibition of torture, there is the right to have some defense in the process, in a judicial process. There's a lot of different human rights that everybody should be enjoying. But there's two in particular that I want to refer, which is Article 7 and 8. Let's talk to 8, as is the most relevant for this lecture. The Article 8 of the European Convention of Human Rights is the right to respect for private and family life. Okay. Everyone has the right to respect for his private and family life, his home, and his correspondence. This was drafted in 1953, so you can imagine that the sort of correspondence that we were imagining back then was different than today. So at that time, it was mostly, as I said earlier, you cannot open someone else's letters, right? Or you cannot look at the papers of someone else's office. Everything was printed out and everything was written on paper. So that was correspondence at that time. The Council of Europe had to actually evolve in that sense and clarify that today correspondence is also, you cannot check someone else's email and enter in someone else's email account or check the WhatsApps of someone else's phone, or whatever information is in this like tablet or computer, laptop, whatever, like anything that you put on internet is considered and that you're sending to another person, no one else should be able to access that, whatever format is, okay? Obviously then there is a second sort of like article, number 2, saying that there shall be no interference by public authority unless it's necessary in the democratic society and for national security interests. This is basically saying, unless police needs to know, right? And for security purposes, needs to get some information. And in this case, obviously, this right to privacy is going to be diminished. And security is going to be, obviously, taking the priority here. This, what it's showing us is that the right to privacy is not absolute. Okay? It has to be balanced. Later on, in 1981, the Council of Europe decided to go and regulate something a little different. This time was not the right to privacy, but it was the right to data protection, which we have already clarified that they are not the same concept, okay? There was a convention, what I said, the 108 Convention, which says, which regulates anything that involves automatic processing of personal data. You can imagine that in 1981, the internet was emerging, but like, not everybody had internet in their house, and the ones who had, they had maybe one single computer, the house computer, and then they would just switch on the router, and they would do like a few, like a little search on the internet, but there was not that much use of automatic processing of personal data still. But the thing was emerging. And the Council of Europe said, you know what, I think we need to regulate that. Because the automatic processing is starting, and there is a prospect that it's going to be increasing all over the years. We need to protect the personal data that are processed automatically by the digital tools, okay? So that was the first sort of like, and at that time, obviously, it was very pioneer, this convention. It established also exceptions, saying, for example, for public security, obviously, the data could be accessed by public authorities, and it established some principles that should not be violated. The document was saying, for example, that the collection of data should be lawful, okay? That it has to have legitimate purposes. So you have, whenever you collect data and you use data, personal data, by the way, here, sorry if I said data, it's personal data, right? I have to emphasize that because you can use data wherever you want. If it's not personal, then this is not applicable, right? But if it's personal, then you have to use it lawfully. You have to use and show that it complies with legitimate purposes, okay? That it's adequate, accurate, and that means if it gets out-fashioned, outdated, you need to update it, right? It cannot be retained forever, just in case. It needs to be deleted whenever it's no longer necessary, okay? These were very first innovative principles back in 1981, okay? Then I have to say the European Union decided that since the Council of Europe was already establishing some conventions, the European Union said, you know what, we're also going to regulate data protection. Because for us it's really important. You can imagine that the European Union, as I said, started as an economic union, right? So in the 90s, we already had the possibility to go all over Europe because we established the internal market. And the internal market means that, for example, if you had a business, I'm from Spain, right? And I decided to provide my services also in France, in the UK, the Netherlands, and all the countries. I can do that, right? And I could provide these services, these goods. I could freely move around the European Union with no boundaries. And that also implies that there is an increasing flow of data all over Europe. The person who's taking a flight from Spain to the Netherlands to, I don't know, go for, I don't know, providing, like, buy some, purchase some services or whatever, like, this data is going to circulate from Spain to the Netherlands, right? So there is, because of this internal market, basically the increase of, like, the data protection was very much relevant to regulating the European Union. So today, and before I'm gonna give you this list of laws. I don't want to bore you explaining each of them, but just for you to understand, there is so many places where you can find data protection regulated in the EU. The main article is Article 16 of the Treaty of Lisbon. Treaty of Lisbon, probably it sounds really weird to you, but in the European Union we use treaties. It's like our laws, right? So you have to imagine, for example, in Georgia you might have a constitution and then you have like a bunch of laws, right? So the constitution at the EU level would be the Treaty of Lisbon, right? And then the Treaty of Lisbon provides some basic legal bases, right? Some basic articles, and then these can be developed into other secondary laws. So the Treaty of Lisbon basically has these articles that you find here, the 16, the 39, and then there is a Charter of Fundamental Rights, which are relevant for data protection today, okay? Besides that, we have Article 8 of the European Convention of Human Rights that I just mentioned. And I'm going to skip the declaration, it's not important. The Charter, what is the Charter of Fundamental Rights? Wait. Here in the European Union, we decided that it's not enough to have the European Convention of Human Rights and to have the Treaty of Lisbon. We are very much involved to protect fundamental rights and human rights, so we're going to create a charter. Why? Why not? So in 2002, the governments and the Commission and all the actors involved in the European Union decided to draft this charter, which basically is a catalog of rights, okay? And they use that as a reinforcement of the fact that they want to encourage the protection of rights, blah, blah, blah. This, since 2009, since the Treaty of Lisbon, has become binding. So basically now we have a Charter of Fundamental Rights with a catalog of rights that all the member states have to comply. If they don't comply with these rights, they can be sanctioned by the European Court of Justice. Big sanctions. So it's not a joke anymore. One of these rights in this catalog, in this charter, is what you can see here. Article 7, respect for private and family life. Everyone has the right to respect for his and her privacy, family life, and communication. It's very much similar to what we have read in the European Convention of Human Rights. It's not a coincidence. The European Union has always tried to get the same or copy the same model and reference than the European Convention of Human Rights and vice versa. That's really important because if there is some sort of clash and some sort of incoherence between these two documents, there must be a problem. Which one should we apply, the convention or the charter? they should go aligned. And that's what they have been trying to do with that. Also, Article 8, protection of personal data. Everybody has the right to protection of personal data concerning him or her. Such data must be processed fairly, specified purposes. These are the same sort of like principles that we have read before. So you can see that we are very aware of the need to protect personal data and to protect privacy. As you can see here, we have divided into, like, Article 7 would be privacy, Article 8 would be data protection. So we are also aware that there are two different concepts that should have two different regulations, okay? But it all was not that easy before Lisbon. So just to make you understand, we used to have a directive in 1995, okay? This one that you can see here, Directive 95/46, which was a first directive that was saying that, you know, personal data should be protected, companies should actually, you know, take care of the data of the users and so on. But this was a little bit outdated over the years. For example, there was one thing that was really problematic. This thing was that there was a territorial scope. So that means that, for example, if we have a company from Spain that is collecting data from people from all over Europe, right? Let's say, for example, I create a company right now, right? And I make a website, and the website has subscribers all over Europe, and I, you know, sell a lot of products all over Europe. Then I collect data from different member states, and that's fine. Then I have to apply this directive. But what if my company is from the United States? And because it's a multinational company, it basically allows, you know, doing these purchases and that this transfers. And my customers are also European, right? Well, in that case, if you can certify that this processing of data has taken place outside the EU country, the EU, then this directive should not be applicable. Let's put an example to make it easier for you. WhatsApp, okay? WhatsApp, it's a company that, as you know, it's located in the United States, okay? The headquarters are in the United States. Even though WhatsApp has been established globally, you're using it, I'm using it, everybody's using it. If me, being European, wanted to apply the EU standards and, for example, access my data, so ask WhatsApp, oh, could you give me the data that you have from me? They would say, no, sorry, because our processing is outside the European Union, so we don't have to comply with the EU standards. So you don't have this right to access according to our regulations. And then me as a European citizen would become completely confused and with no possibility to any sort of like appeal because of this unprotected situation outside the territory of the European Union. Okay, so this is what happened in Directive 95/46. It worked fine until a certain time, and then what happened is that because of the new technologies and all this like digital era, and the fact that nowadays we can just, you know, access projects and websites and commerce from everywhere in the world, it had to be updated. Otherwise, EU citizens were pretty much unprotected when they were doing operations outside the European Union. The core values, I'm not going to read them, but they are the same as we have seen, or pretty much the same as the ones we've seen in the Council of Europe. So use limitation principle, purpose specification, and so on and so forth. Now, let's give a few words. I don't know how much time I have until the break, but I'm going to use 15-20 minutes more just to tell you what are the new things today with the new legislation. So, the new legislation, basically, as I said, it's entered into force in 2016 and was fully applicable and operational in 2018, May of 2018, okay? It's basically what you see here, regulation of the European Parliament and the Council for the protection of individuals with regard to the processing of personal data. In short, GDPR. By the way, there is another piece of regulation that I really like because this second one was basically part of my PhD a few years ago, which is the data that is transferred and that is processed for security purposes. So, the first instrument is for private companies. The second instrument is for police and law enforcement. I want to clarify that because the protection of data, if the data is used for commercial purposes or the data is used for security purposes, is totally different. And in other words, the first piece of regulation is much more strict than the second one. Why? Because what we understand is if it's to protect, some security threats and so on, probably you will give up more privacy in order to improve this security. Whereas companies that use this data protection, their personal data for commercial purposes, they should have the same sort of conditions regardless. Why a reform? Well, what I said, there has been an increase of the internet access and the access to the digital tools in the last year. You can see this graph, computers in the internet access. So from 1985 to 1990s, nobody had there was maybe one computer in every house. And then that changed by the end of 1990s, and then in the 2000s until today, everybody, not only there is one, everybody has its own computer, but also we have all sort of other devices like tablets and smartphones, and we're constantly introducing personal data into each of these devices. So there was a need to change the regulation accordingly. Another thing that you don't have to know, but I always explain to my students, I teach EU law in Barcelona, and I explain to them, one thing I explain is the difference between regulation and directive. So basically, to make it very easy for you, so I explain to you that there is a treaty as the constitution of the EU. Don't say constitution because it's not actually a constitution, but just for you to picture it. And then there is a bunch of secondary laws, right, that hang from it. These secondary laws could have the form of regulation, directive, decision, recommendations, opinions, whatever, you name it, right? One thing that was very crucial is to change the protection of data from a directive to a regulation. So now GDPR is General Data Protection Regulation, right? So it's a regulation. It used to be a directive. Why is that different? Well, the directive, one of the things that basically does is that it gives some minimum rules, and then these rules need to be developed by the member states. So it says, for example, okay, you need to regulate this, this, and this, and this. It summarizes, right? It gives a little idea of what you have to regulate, but then the member state is free to decide how to regulate this issue. Okay, so for example, you member state has to establish measures to, to protect data when there is some sort of data breach. Period. You put the measures, you put the security measures that you want. A regulation will not say that. A regulation will say, you member state will have to protect data from data breaches, and you will have to put and you DPA, the Data Protection Authority, and then you have to repair the damage and you have to compensate. So, in other words, beep, 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 everything has to be very much specified. There is no leeway, there is no margin of appreciation from member states to decide how to comply with this particular article. It's already there. You have to copy and paste it. Period. And this is a very good thing on data protection, because one of the things that happened before this regulation is that every member state had different laws on data protection. So, for example, in Spain, we would have, whenever there was a violation of data protection, the sanctions were very high, really, really high. Whereas if you would go to the UK, the sanctions were affordable. So a lot of companies would say, oh, I'm going to go to the UK, because if I get a sanction on data protection, this is going to cost less than if I go to Spain. So there was a lot of forum shopping because of the differences in data protection, and a lot of companies took advantage of that. Not anymore. Now there is a single regulation applicable equally in every member state. The principles are pretty much the same that we had before. There is some new ones, like, for example, data minimization, or the principle of accountability. But the others are pretty much the same. I'm not going to go into this because I want to have time for other things. One of my favorite novelties, extraterritoriality. Oh my God, I said the word right. I always get in trouble with this word, extraterritoriality. What does it mean? It means that, remember the case of WhatsApp that I explained before? Well, no longer can be an excuse for WhatsApp not to give the information of the for the EU citizens. So now it's not enough that the company is located in the EU territory to have applicable this law, but even companies that are outside the European Union, so maybe Georgia, wherever, if there is some sort of like services or data that is involving EU citizens, right? So, for example, the services are accessible for EU citizens, or this particular company is monitoring the behavior of EU citizens, or is offering goods to EU citizens. If any of these cases applies, this company, regardless of the fact that it's located outside the EU, has to comply with the GDPR. Okay? So if you have a company in the future or the present, and you're offering services or goods for EU citizens, you have to adapt your legislation accordingly. Also, there is more obligations to be applied for data processors. Remember the concept, data controller, data processor. So in the past, as I said, the most responsibility was for the data controller, who had the direct link to the client. Nowadays, there is also obligations for data processors, because more and more you delegate all these services to other people who are more specialized in treating data. So it should be fair that these people have also rights and obligations. Consent. The consent has to be free, informed, specific, and ambiguous, and sometimes even explicit. Let me clarify that for you. When you will give your information to these companies, let's say today, you download a new app on your phone, right? The first thing that are going to be requested is give me your email, your password, and some other bunch of personal data. Well, when you put this data there, you're going to be consenting that this application company can use your personal data for their own commercial purposes, okay? This is normally considered consent, because you are freely given this email address, this password, this name, this surname, whatever, right? So you're giving consent. If you would region, for example, sexual orientation, then it's not enough to just write your name or write this piece of information. You need to give explicit consent. Probably you will have to check a box saying, I consent that this information is given to this company. Why? Because this is considered sensitive. So for sensitive information, the consent has to be higher. It has to be explicit. Okay? One other thing that we have as EU citizens is that we have the right to access to any data that we have given to any company. Okay? We have the right to rectify this data if it's incorrect. We have the right to object, to say we don't no longer want to, I want you to just delete this data and to stop using this data. We have the right to restrict the processing. And we have another right that is very interesting. It's very also novel. It's called the right to be forgotten. Anyone has heard of this? The right to be forgotten. I'm going to explain a case. This guy here that you see is Mario Costeja. Okay? He became famous because of a case that arrived to the European Court of Justice. What happened to him? Well, one day he woke up, he typed his name on Google, and he found out that the first entry on Google was a piece of news of 12 years ago of one of the Spanish newspapers called La Vanguardia, saying that he had so many debts and that because of that he had had problems with the Spanish government, and that and there was a big article explaining all this like situation that once a long time ago he had. I have to say, at the time that he entered his name and found this piece of name, he obviously had paid off all his debts. He was already like complying with all the laws, and this piece of name was no longer current and accurate, right? But whenever he went to the La Vanguardia, to this Spanish newspaper, and he said, "Hi, can you delete this piece of news because this is not relevant, and like also this is affecting me. I have a business, and if someone is typing my name and see that, probably I'm not going to be successful in my business. So please, can you delete that?" La Vanguardia, the newspaper, said, "Sorry, no, because we are a newspaper. We informed that a long time ago, and even if it's not relevant, it's still a piece of information. So we cannot do that." By the way, I have to say that this happened because at some point, and probably here in Georgia it happened as well, a lot of newspapers decided to digitalize all the content that used to be on paper a long time ago. So what happened in Spain and in a lot of countries is that they just scanned all these old newspapers and put it on the website. So that's why all of a sudden he found this piece of news on the internet. Anyway, after that he said, "Okay, what else can I do? Okay, I'm going to go to Google and I'm going to say, Google, can you delete this entry?" And then Google said, "Oh, no, because, I'm not the one who processes data. It's the newspaper who has processed data. We only index data. And by index mean that there is some sort of like random patrol of the information that is out there on the internet that we just, blindly put over there, but we don't just go entry by entry checking if that's accurate or not. So sorry, we're not gonna be able to do anything." So this guy was completely helpless. He could not go to the newspaper, he could not go to Google, nobody was responsible of that. And he went to what is called the Data Protection Agency in Spain. By the way, every country has at least one data protection agency. And the And the Court of Justice basically said, yes, Google is a data controller. Its search engines can be data controllers. Because even if they are indexing, the fact that they are indexing all this information, that is considered data processing. Because they still have the capability to rule out, to delete some information or to restrict some websites. And this is not enough to say, oh, we just blindly and randomly update everything without any checking. So basically what it was saying is there is a right to be forgotten in cases like this guy who didn't want this information to affect his life. He was not a public person. The information was not relevant anymore. It was all piece of information, and he had already complied with everything, with all his debts and whatever. So in this case, was justified that he wanted to be forgotten. So this was a landmark case because after this case, a bunch of people also contact Google and say, oh, I want to remove this piece of information that I have. And now there is a possibility you fill out a form and Google will check, obviously case by case, but there's a lot of people that can enforce this right to be forgotten if there is some information and go on Google that you don't want it to be. Anyway, and just to finalize, all the new stuff that is on the data protection regulation, in case of data breaches, the EU citizens affected need to be notified as soon as possible, and mostly in the first 72 hours. So in 72 hours, if your data has been compromised by a company that has been hacked, you need to receive an email saying, please update, we have been, whatever, we have been hacked and you need to change your password, and this data has been compromised, so please take care. They have to do that because before there was no time limit, so it could happen that there was a company hacked and then only 1 month later we got notified, which was already definitely too late. So that was one of the things that they needed to change and put only like a very short period of time for citizens to really like take responsibility of it. We have another concept that is pretty interesting. Data protection by design and data protection by default over there. That means that everything, every company, every application, every service that we create has to be by default data protected and by design. So it has to give all the users options to manage their privacy. I want to create my profile public, not public. I want to delete my data in 6 months, in 3 months. You have to give the users options, right? The design has to contain data protection options. Now, another thing that is interesting is that every company that has a certain amount of workers has to include in one of their departments a DPO, Data Protection Office, okay? This is a department that will deal only with data protection. That means that if you own your company, you can also have some subcontracted data protection officer, but if it's big enough, they will have a department that deals only with data protection. For example, my brother, he's a DPO in a pharma company. And in this pharma company, they have created a department, and he's the one that deals with, obviously this pharma company has a lot of branches, but he supervises that in that particular company, they take care of everything that has to do with data protection. And also the fines are really, really high now. They are up to 10 million euros, or 2% of the total worldwide annual turnover. And that could happen if, for example, if you skip the rule, if you collect data without consent, that could end up with a fine. If you don't comply with the data subject's rights, like for example data access, and so on. what happens if I had something against Facebook that I wanted to go and start proceeding because of whatever violation? I had to go to the Irish DPA and I had to start proceeding there in a different country. And that could be a burden. Imagine I don't speak English, or I don't know the Irish laws, or I don't know how to start proceeding there. So a lot of people found it really, really complicated to start proceedings when there was no mechanism to access it from your local DPA, Data Protection Authority. So what the regulation, the General Data Protection Regulation has created is a one-stop shop mechanism. Meaning that if I have a problem with Facebook or with Twitter or whatever, that they are located in Ireland, I'm going to go to my Data Protection Authority, and the Data Protection Authority of Spain is going to contact the one in Ireland. They are going to discuss and start the case, and I will never have to go to Ireland or deal with the Irish authorities or anything like that, because I will go directly with my local DPA. And that makes things much easier for citizens that have no clue and that might be victims of violations by companies. Okay? Thanks for your attention.